everyone, and welcome to another episode of The Forum, the podcast by the Diplomacy, Law and Policy Forum. Today we have with us Raas Nabeel, who is a research associate at the Research Society of International Law, and he will be talking to us about the Law of Neutrality. So, Raas, just to start off with, can you tell us the distinction between what is a belligerent state and a neutral state under the law of armed conflict, and what are their corresponding rights and obligations?
Cool. So, belligerent state, basically, just to sum up what that means, is a state involved in conflict. So, belligerency is the sort of state of being in a conflict, and then neutrality, its opposite, would be a state that is not involved in a conflict. It may not necessarily be as black and white as that, because you may ask, what if a state supports another state that is fighting, that is a belligerent, but does not necessarily get involved itself? Depending on the type of support that they do provide, so for example, if they provide military support, they would be classified as a belligerent themselves. So again, while the demarcation may be, very black and white in that sense, there are quite a lot of gray areas in this area of IHL. But again, the rights of neutral states, at least as espoused in the original conventions, so we had the Hague Conventions 5 and 13 of 1907. Basically, the main rights were that the territory of a neutral state was inviolable by any belligerent state. So any territory of a neutral state cannot be used for any sort of military advantage by belligerent states. So that would usually involve the invasion of armies, or using the territory of a neutral state as a shortcut to get to another state. So those things are sort of some of the rights of neutral states and obligations of belligerent states. But again, neutral states also do have certain obligations. So if they do find combatants of belligerent states on their territory who are wounded, for example, they have to provide them relief and medical aid. They also do have to maintain neutrality in the sense of diplomatic and economic relations. So they have to maintain trade relations with both belligerent parties, or all belligerent parties, regardless of who is aggressor or who may be the victim state. So that, again, that classification does not necessarily apply. For neutral states, they have to, to maintain neutrality would be to treat both parties equally, and that would mean regardless of who violated international law, they would still have to maintain diplomatic and economic relations.
So there's kind of a right to inviolability so long as you maintain your duty as a neutral state, which is to abstention and impartiality.
Basically.
And then the duty of the belligerent with regard to the neutral state is respect for that inviolability.
Exactly.
And so that's, in terms of how the law of neutrality is violated, it is if you don't ascribe to these obligations, which is that you provide material arms transfers, aid to one of the belligerent parties, then you're no longer a neutral. And even if you allow for the transport of munitions or the transport of troops through your territory, that's a violation of your obligations as a neutral state. So in terms of, we know that this law kind of emerged in the 18th and 19th centuries. So how has it evolved? Because now states no longer, especially because the rise of global trade and commerce and globalization is such that you don't really have, you have states which operate their bases on numerous territories. You have states which continue to undergo trade even of arms with parties engaged in conflicts. So how has that evolved now from the concept of neutrality to the concept of non-belligerency?
I think with the notion of neutrality, we do have to contextualize it in the just war doctrine. So if we look at the 18th and 19th centuries, and then even to some extent the very early 20th century, war was justified. So a state could validly engage in war if, for example, there was a dispute over territory, or if they wanted to claim sovereignty over another land. So colonization, again, was seen as, in that time, it was seen as justified. And so if a state had the right to wage war, other states had equally the right to abstain from war. And so neutrality essentially stemmed from that if a state is engaged in hostilities, to protect the interests of neutral states, lives, their economy and everything else, they would be like, okay, you know what, we're going to step back, you guys go at it, we're not going to get involved, but we're going to treat both of you guys the same. But now, after Article 2.4 of the United Nations Charter, which prohibits the use of force with two exceptions, collective security and self-defense, with the now globally accepted prohibition on the use of force, states cannot wage war, and states are not justified when waging war. So then neutrality in that sense is a default position. All states are essentially, they have to sort of maintain a sense of neutrality by default if the use of force is prohibited. However, what we're seeing nowadays is that even where the law is violated, so where states do use force, so when there are acts of aggression, states are now at least showing support, usually for the victim state or whichever state has not violated international law. You see states at least extending an arm of support in their favor that would usually translate to the provision of aid and other such resources.
But, arms, etc.
Yeah. But again, the concept of non-belligerency, like you talked about, is showing that support but not getting directly involved in the conflict itself.
Yeah, and I think that the movement has really been towards the notion that this does not. I mean, states haven't come out and said like, oh, we've breached our neutral duties. Yeah. What they've said is like, oh, but we're still non-belligerent. Yeah. So it's this argument. I think that we're kind of seeing the fruition of some kind of custom, which may crystallize or be codified later, in which states are arguing that this doesn't really count as a breach. There's a new norm by which we can, if there's an aggressor state, we can be supporting the victim. And I think we are seeing this a lot in the context of Russia and Ukraine, where states do not think that they might not be neutrals in that conflict, but they definitely don't see themselves as co-belligerents with Ukraine or in any way.
For sure.
And so, again, the notion of non-belligerency, and again, we saw that, I think, with Italy maintaining bases in the Iraq War, American bases, during the Second Gulf War between America and Iraq. And again, Italy said, but we're non-belligerents, we have not engaged in this conflict. And I think that it is really interesting to me seeing the values espoused by the law of neutrality, because it is this desire to maintain international trade and commerce between countries, despite there being an armed conflict taking place between two or more. And you see that so much in the context that the obligation is on states to not supply these weapons and to not supply this aid. But even in the 18th, 19th centuries, apparently, because of the war profiteers, the private persons were not prohibited. And now that we're seeing such a rise of corporations and companies and kind of the business of war. So say, would it be incumbent upon the US to prevent Lockheed Martin from supplying weapons to any other state? And I think at that time they decided no, and you still see that, okay, so that would not violate the law of neutrality. And I think for me that was one of the most interesting things, that okay, it is only on the state, but whatever corporations are within the state or premised on its territory, they don't really need to abide by these principles. And I think going forward, again, with the rise of this concept of non-belligerency, it kind of maintains that the value is on international trade and commerce. So whoever wants to buy our weapons, that's not us getting involved in the conflict, really. So I think that's quite an interesting development. And again, you mentioned the UN Charter, and there's been so much talk about how under the UN Charter, the prohibition on force of Article 2.4, you have two exceptions, which is self-defense under Article 51 and collective security operations by the Security Council. So how does the Security Council authorization of the use of force impact the law of neutrality?
So again, the Security Council can authorize both measures falling short of the use of force and measures involving the use of force. Again, with measures short of the use of force, we could talk about sanctions. And so the UN can mandate that a country that has violated Article 2.4 should have sanctions placed on them. And these will include various economic sanctions, trade embargoes, arms embargoes, etc. So by virtue of being part of the UN, you have to abide by that.
Yeah.
And so now with that duty upon you, you can't really express your neutrality because then you would be in violation of your commitment to the United Nations. I don't know if you wanted to add on to that.
I mean, I wonder whether this is a bit of an overstated exception to the law of neutrality, just because I've never seen the UN Security Council, it has authorized member states to use force. But we have seen that you don't have the UN Army, which was originally conceived under the UN Charter. So the Security Council does have to rely on member states to do it. But I don't know if I know of a case where the Security Council has forced a member state to use force against another one, right? It's just authorized it, and anyone can take them up on that as having legal cover.
Right.
But I think it does come into play when you have the notion that, okay, if you have a UN special force, which is conducting, which is acting under Chapter 7 powers, and they are required to pass through another state's territory, then you would have to allow them to pass through.
Exactly.
So that's when I think it can become a bit more coercive. So how does the law of neutrality interact with that? So I think that in that case, you would have something which kind of trumps it, which is the UN Security Council's powers.
Yeah, I do think the presence of international organizations and just general like non-state or supra-state actors does muddy the waters a bit when it comes to neutrality. Like you said, that is a state allowed to reject UN forces to pass through, regardless of it being a member state or not. But again, similarly, we can also see how, in terms of muddying the waters with neutrality, you could also see how the rise of non-international armed conflicts involving non-state armed groups and states, how that also sort of is a gray area when it comes to neutrality. The Hague Conventions 5 and 13 were envisioned, or they were at least conceptualized at a time when war would take place between states. So it would be an international armed conflict. But now you have increasingly, or at least the majority of conflicts, one could argue, today are non-international armed conflicts. So they involve non-state armed groups. How does that then how does neutrality then apply there? Because again, technically this the non-state armed group does not have its own territory per se, but if it is exercising effective control where the government of the state, the state apparatus has broken down, does that apply there? What is the effective control test? How would it look like? What if another state decides to get involved on part of the state or on part of the non-state armed group? Do states have this obligation not to get involved with non-international armed conflicts? Or if there's clearly overwhelming support for the non-state armed group against a tyrannical state, so some would say, does the state then have a moral duty to help out, humanitarian intervention?
Yeah, and I think some people are very clear-cut about this in the sense that they're like, it doesn't apply in non-international armed conflicts. So in non-international armed conflicts, we don't have the law of neutrality. As in, Nicaragua concerns would play a part in terms of how much are you intervening, TADIC, overall control or effective control test, state responsibility. But I think it does become more complicated when you have these internationalized non-international armed conflicts. I know some people hate those terms, spillover, NIACs, like what happens in those cases, and especially then because now we have this parallel, so where you have an NIAC occurring and you have an NIAC, so how does that occur? And I also think one of the other major concerns right now about cyber is how it changes so much about how we apply IHL. So in terms of how would we apply IHL to the cyber realm, and even when we, one of the things that I was just recently looking at was the concept of cyber espionage, because espionage requires that you're on another state's territory and you're walking around and you're looking for information. How do you do that when it's in the cyber realm? And how can you have people convicted for espionage under that? So similarly with the law of neutrality, how do you have, what is the onus on this neutral state to prevent its infrastructure, its servers from being used by co-belligerents?
Yeah, I think cyber, or at least cyberspace, does again throw up a lot of questions about neutrality and whether at least how it's espoused in the two conventions is still relevant, or even under customary law, because again, the nature of cyber or like cyber warfare is that it takes place over an intangible sort of realm.
Yeah.
And we're not used to seeing that. Conflicts in the past have always, at least to some extent, involved, to a major extent, I would say, they have involved territory. If not territory, then at least some sort of physical realm. So if conflicts would take place in outer space, at least you would be able to demarcate, okay, this is, this is the International Space Station, or this is a, a satellite belonging to this state. So at least you were able to tell. But with cyberspace, especially when you have globally shared spaces like the internet, how do you really say whose cyberspace belongs to which state, or which cyberspace belongs to which state? Again, with the notion of infrastructure and things like servers and telecommunication networks, I think the Fifth Hague Convention does talk about the fact that a state is not allowed to let a belligerent state use its information communication networks to route certain attacks, or to to gain any sort of military advantage, whether it be through announcing an attack or whatever. But I think now with cyber, the issue is, can you attribute a certain attack to a different state? Attacks can also be routed through servers that are placed on the territory of different states, or they may be servers that are commonly shared. There could be private servers as well, owned by private corporations. And so do you look at where that corporation is registered as then, the neutrality of that state? So I think the main issue is with attribution. And if you're a neutral state and you are unaware of an attack being routed through your servers, are you then held accountable for violating neutrality? Are you then a co-belligerent? Is there a degree of, is there a burden of proof or a burden of knowledge that you need to prove of whether you had knowledge of the attack being routed through your servers or not, or like, is there a due diligence requirement?
So, and I think that due diligence requirement of being like, either you now know about this being used, your infrastructure, your servers, computers on your territory are being used to conduct attacks by a belligerent, not a co-belligerent with you, but then it's the onus is on you then to uphold your duties under the right of the law of neutrality, under the law of neutrality, and to stop it. But I think that states will often balk at that notion of the due diligence requirement because it's so difficult to find out. So even if it does come to their awareness, or if you have that wider kind of, I'm thinking of international criminal law now in the sense of you should have known. That is going to be one which is really, really difficult to hold states up to, essentially. And I think one of the other things to look at in the context of technology is the fact that you have, technology is not one of the prohibited things in terms of how you can give aid to a belligerent state. And as technology becomes more and more important, it's interesting to see whether states will see technology transfers as meaning that you are either non-belligerent or you're breaching the law of neutrality. So I think going forward, that will also be the cyber realm. And in terms of technology transfers, how does the law of neutrality evolve to deal with that is going to be one of the things that will be most interesting to watch out for in this regime of law. Thank you so much for joining us, and we hope you tune in for your future episodes. Thank you.